Good evening. I'm delighted to welcome you all on behalf of the LSLC and the LMAA. For those of you who may not know me, I'm Aleka Shepherd, the chairman of the LSLC and a maritime arbitrator. This event marks a new chapter in the centre's evolution. It is our first hybrid, a remarkable achievement of technology and a positive outcome of the pandemic. My role today is to inaugurate our hybrid events. So I'm very pleased to announce our partnership with the IDRC, which provides the venue and technology. The IDRC, in its new premises, is the finest and busiest centre for dispute resolution in the world. We organise this event in association with the LMAA, and I thank David Stewart, the President, for proposing the subject and for hosting the reception afterwards on behalf of the LMAA. We have a splendid panel of speakers and a delightful chairman, Simon Rainey QC. As you know, his reputation precedes him. I should just say that he is acclaimed for his advocacy skills, clarity, analytical thinking, as well as charm. Given his practice in the field of energy disputes and his writing on offshore contracts, I chose him well to be the chairman of this event. Over to you, Simon, and thank you.
A very great welcome to you all to this joint LSLC-LMA hybrid seminar, the first in the series. It's very good to see so many people attending in person, but a very warm welcome to those who are joining the event virtually. Tonight's seminar, as you'll see on the screen, considers aspects of offshore energy disputes, and it's subtitled Contracts and Disputes in the Maritime Environment. And our speakers, and we have an illustrious panel who I'll introduce in due course, are going to be exploring what I might call the crossover between energy-related disputes and London maritime arbitration, and common features in certain offshore and maritime contracts and disputes. I'll give us one example, which is going to be considered this evening, the contracts relating to the offshore supply and offshore energy construction industry, forming part of the BIMCO suite of standard form contracts, supply time for offshore supply vessels and wind time for vessels servicing the wind farm industry. Energy-related contracts, but closely rooted in maritime equivalents, time charter parties, albeit with significant differences which come from the energy world, but all providing as a default for dispute resolution arbitration under the LMA rules. I'll give us another example of the crossover, another one of our speakers will be considering, the crossover between the standard shipbuilding contract, the staple bread and butter of LMA arbitration, and complex offshore construction and marine engineering disputes, which share many features. The format this evening, let's see if I can get the first slide to go up. Yes, there it is. The format for this evening, we have our three panelists who I'll introduce in due course, and we have three specific issues to be discussed. The order which they come up on there is not the order in which the speakers will be addressing you. The panel will warmly welcome questions, both from you here from the floor and from those of you who are watching virtually. I believe I'm told there is a chat function or question function on this, which I will endeavour to find, but otherwise just email me, simon.rainey@quadrantchambers.com, and I'll pick it up on my phone. And as Aleka has said, the LMA very generously is hosting drinks. They're all there waiting for us after the seminar, so please stay if you can. Our first speaker is Adam Constable, QC, rightly described in the directories as one of the best construction lawyers and silks of his generation. To those of us who practice in this field, he is the general editor of that invaluable book, which explores the crossover between shipbuilding, construction generally, and offshore construction, Keating on offshore construction and marine engineering. Now I'm glad to say in its second edition, and Adam has said that there'll be a third edition coming along shortly. His topic, now I'm just going to find his slides, his topic is the vexed one of the prevention principle. Is it right? Should it be applied in the shipbuilding context? Where is it going? Adam described himself in the first edition, I haven't checked whether it's the same in the second edition, as a partisan in this area, and it's difficult to think of a better guide to the thickets of cases like Adyard and North Midland than Adam. Just let me now bring up Adam's presentation. And look at that, effortless. Yes, thank you very much.
Absolutely, yes. Thank you, Simon. Well, I hope that this talk is as deft, as skillful as the bringing up of the slides. This is going to be a little bit of a whistle-stop tour, I'm afraid, but that is because there's a lot of ground to cover. I'm going to start, and again, apologies for the slightly cheeky extract from the preface to the second edition. I should say that the third edition is en route, but I think swiftly or soon is a bit optimistic. I think it won't be around until next year, I imagine. These are the words that Lord Justice Hamblin, as he was then, and Vivian Ramsey put into that preface. And in particular, they identified one of the areas that we explored, which is whether or not the prevention principle is correct, and in particular whether or not the all or nothing effect of the prevention principle is the right way of dealing with it. I mean, it always has been in land-based construction contracts, from where I think the prevention principle really originated, but as is explored in lots of cases nowadays, it clearly in the shipbuilding and offshore world has a much more binary and potentially draconian impact when it leads to the disappearance potentially of termination rights that follow 180 days, 240 days, whatever it may be, past the completion date in the context of the SAJ standard form in its unamended form, and in forms where the amendments have not been carried out with a view to the problems that happen with the implications of the prevention principle. So just a starter for 10, we all know what the prevention principle is. It's where there's a contract which stipulates a time for completion. The employer or the buyer carries out something. It doesn't have to be a breach, it could be an instruction, but which acts to prevent the builder or the contractor from completing within the stipulated time, and that employer can't then claim its liquidated damages for non-completion. Now, this was taken from a land-based construction dispute, so therefore doesn't go on to say the other implication, which is that the termination rights that are dependent upon the completion time in turn would also disappear. So recent application, this is Rupert Jackson in Multiplex, and he pretty much put out a modern statement of the prevention principle. First of all, you'll see he draws attention to the fact, as I said before, it's not just breaches that can act as acts of prevention. It can be acts that are legitimate under the contract, so instructions, for example. And importantly, in the second bullet point, is the fact that acts of prevention won't set time at large if the contract itself provides for a regime in respect of those events. Now, most contracts do include some sort of regime or other, including the SAJ. The question, generally speaking nowadays, is whether the regime is complete. And in particular, in the context of shipbuilding contracts, it often focuses on the workings of Article 8, what in the original form was a force majeure clause and is often amended to be a more general delay clause. And the question explored in the cases is whether it is effective to cover off all acts of prevention. And then the last of the three bullet points was explored in a recent case, or at least commented upon, in Zhang Zhu. Insofar as the extension clause is ambiguous, it should be construed in favor of the contractor. Now, in the context of employer-contractor in a construction contract, reference to the contractor it is accepted, would be the equivalent of the builder. And the reason why Mr. Justice Butcher says you have to have a little caution in looking at that third of the three bullet points is that what it doesn't really mean is construed in favor of whatever the contractor happens to be saying is the right answer. It means construed in favor of making the machinery work, because in Multiplex, the contractor was arguing that it was a notice provision, in fact, that the machinery fell apart, and construction in favour of the contractor in that context was related to whether or not the machinery would or wouldn't work. What that bullet point really means is construed in favour of making the provisions work and stay alive. The prevention principle here in Lord Denning's judgment identifies what the consequence of it is when applied, and as we see, it's that the penalties or liquidated damages for non-completion in that time fall away. Contracting out of the prevention principle is a clear entitlement, so it is a contractual mechanism. And again, in land-based contracts, there are two particular ways in which we've seen contracting out. First, in Honeywell, is notice provisions. If you make a notice provision a requirement for relief under the contract, that is a permissible way of allowing effectively the buyer to avoid the consequences of its own act of prevention should the builder not put in the requisite notice. The contract will stay alive. And it was argued in Honeywell that because a contractor or a buyer, and it was argued in Adyard as well, has failed to put in the right notice, the builder is being prevented from achieving completion. Nevertheless, the employer or the buyer is recovering its liquidated damages. That is unfair. It's a contravention of the prevention principle, and therefore the court ought to intervene. And Honeywell says no, if the contract contains clear condition precedents by way of notice, they will be upheld, even if that has the effect of a contractor not getting relief from the obligation to pay liquidated damages in light of an employer event. The second case, which shows that it's a contractual principle and one which can be contracted out of, is the North Midland building case in the Court of Appeal, where Lord Justice Coulson was dealing with a clause that dealt with concurrent delay. And effectively, the employer had inserted a clause into the contract that said, if there is concurrent delay, i.e. delay that the employer is responsible for, that runs alongside the delay that the contractor is responsible for, then the contractor won't get relief under the extension of time principles. And again, it was argued that that effectively drives a coach and horses through the prevention principle. The employer may have done things that has prevented the contractor from completing, but nevertheless, it will be upheld. You can contract out of the principle. Now, in advance of the Adyard case, which was about a decade or so ago, there was in the shipbuilding and offshore industry a good deal of skepticism as to whether the prevention principle applied at all. And that was largely derived from the historic background of the SAJ and shipbuilding contracts, which come from a sort of sale of goods origin, and the fact that a builder or a provider of a good is entitled not to accept instructions, for example, that may change what they have to do. They simply deliver what they're required to deliver, and therefore they can't be prevented. But the application of the prevention principle was made very clear in the judgment of Mr. Justice Hamlin, who said that it does apply. He was considering an amended Article 8 clause from the SAJ, which had an amendment including condition precedent clauses, and the contractor, the builder, was arguing that in circumstances where they hadn't complied with those notice provisions, that the regime should fall away. Happily for my clients in that case, Mr. Justice Hamlin was having none of it. Quite rightly, he said, shipbuilding contract is a contract like any other contract to which the prevention principle will apply. And certainly he endorsed the words of Mr. Justice Jackson in a construing the contract so as to make the contract work, to make the extension of time and machinery work, and to oust effectively the prevention principle. So following on from Adyar, there have been two important cases in considering how the prevention principle works in shipbuilding contracts. The first was Shushan in 2015, considering Article 8, and Mr. Justice Leggett construed Article 8 narrowly. In fact, he said on the construction, albeit an amended version, didn't cover buyer breaches, which would by itself mean that there would be room for the introduction of the prevention principle. But in fact, he went on to describe the contract as a whole as dealing with all the possible breaches that a buyer might, by which a buyer might prevent the builder. And so in the circumstances of that particular case, for example, he said that a supervisor causing delays by failing to turn up for inspections, for example, can't actually prevent the builder because the builder has a contractual right to continue with the work. And whilst that contractually is absolutely correct, one might wonder how practical that is in real circumstances in a shipyard where day-to-day acts of prevention do happen, in fact, and builders do hang around to wait for the buyer's supervisor to turn up. That's actually what happens in real life. And so one wonders whether, although contractually correct, how applicable that is in practice as a solution. There's then the more recent case where Mr. Justice Butcher came to the opposite view in relation to the breadth of Article 8. And albeit it was marginally different in that both had been bespoke amendments, the differences weren't very significant, in fact, if you look at the detail of it. And he adopted a broad definition and said if he had to decide, as it were, he didn't agree with Mr. Justice Leggett's sort of narrow view if it was to be one of broad application. The effect was the ousting of the prevention principle because Article 8 was construed as covering all possible acts of prevention. And he noted the oddity, as was the case in Adyar, that it's the seller in the shipbuilding cases that is very often arguing that the contractual provisions aren't good enough and to bring in the prevention principle, whereas in land-based contractual disputes is often the other way around. So where does that bring us now? What is the orthodox view, and is it working? Well, the orthodox view, as here, is very clear if one goes back through the authorities and recently emphasised by the Court of Appeal in the North Midlands case, is that it's an all or nothing. If the prevention principle comes in, time is set at large and the contractual machinery is effectively set aside. That's the orthodox view. And we can see from all of the shipbuilding cases to which it's been applied, it as a principle has effectively been ousted. So it's sitting there in the wings, but on each of the cases in a slightly different way, the courts come to the view that it isn't applicable. And I think that's probably because, as we'll come on to see, there's a great deal of concern that if you do apply the principle of the prevention principle, one small event can cause a really significant upset to the contractual bargain that the parties have met, in particular in relation to liquidated damages and the right to rescind. Some of the comments in the cases express concern going back through the years. This is Balfour Beatty and Chestermount, which I think is a 1980 case. Mr. Justice Coleman it expresses the view of some concern what might be a trivial variation instruction would destroy the whole liquidated damages regime. And that really is the worry. This is Mr. Justice Ramsey, the principle of some antiquity, and has a surprising effect of the contractual obligations as the time for completion. So he's surprised. And we can see Lord Justice Phillimore back in 1970 was not just surprised, but startled indeed. And he was concerned that, again, a very small problem might lead to a very large coaching horses being driven through the contractual machinery and bargain. So where does all that leave us? It's certainly clear that as a matter of authority, at least to the Court of Appeal level, it seems that we are stuck with an all or nothing approach. But what is clear from the authorities is that it is a principle of contract. It isn't some rule of law that has overriding powers. It's one of contractual construction, either by way of implication or construction. And so one has to ask, certainly in the 21st century, why it is indeed obvious or necessary, if that's the test for an implied term, that an act of prevention would indeed cause the machinery to fall away. If one is inserting into the contract, as you are by introducing the prevention principle, words that don't exist expressly, why would those words that are being introduced not include the simple phrase "to the extent that"? So if one has a breach or an act of prevention, it will prevent liquidated damage from being applied to the extent that the act of prevention has caused the contractor to miss the completion date. It seems to me nowadays one would think that is a pretty obvious conclusion. Certainly the shipbuilder on the Clapham omnibus, if there is such a thing, would suggest that that's obvious. It might be that the test of necessity is a little more difficult to jump over, but it does seem to me once you've got over the hurdle of accepting that this is a contractual construct rather than a rule of law, which it clearly is, then I think the 21st century solution to that contractual construct should include what seems to me the very sensible way, the very sensible solution, that the relief given is given to the extent of the problem and doesn't cause both sides bargain to disappear, be it for liquidated damages or in relation to the right to terminate. So that was a whistle stop. I might have gone over a couple of minutes, for which apologies. But
I will say nothing. Thank you very much indeed for that very interesting and magisterial consideration of the authorities in this complex area. Our next speaker is David Stewart, steeped in offshore energy matters from 30 years of practice at Ince & Co, and since 2011 a busy and sought-after arbitrator under the LMAA rules and a host of other institutional arbitrations. He became president of the LMAA in 2021, and it's a very great pleasure to be on a panel with him. His topic is one very dear to my heart, knock-for-knock regimes, with which I've spent many happy hours writing about and advising on, and in particular, the different BIMCO offerings as knock-for-knock clauses in the supply time form and the wind time form. He's got quite a tough gig, ladies and gentlemen, this evening, because in the second row is Chris Kidd, who was on the drafting committee for the wind time form, and who can perhaps explain why they went to the TOCON form rather than the supply time form as the starting point for the drafting of the knock-for-knock provision. Perhaps you're going to be covering that.
We'll ask him that in due course.
Okay. And so now if I can just see if I can screen share and put his talk on, you will see that David's talk, perhaps optimistically, is called Keeping It Simple.
May I have the conch shell?
You may have the conch shell.
Adam reminded me a moment ago that that book did not end happily.
No, be careful. Be careful what you wish for, David.
Great. Thank you very much. Well, thank you, Simon, for that introduction. A very good evening, everybody. I have two housekeeping matters, as we arbitrators invariably say. One is that I'm afraid I will not be able to join you for the drinks afterwards, because immediately that we finish, I have to hightail it off to Newcastle for a meeting tomorrow. So apologies for that. The other thing is that I'm going to rattle through some authorities this evening, and you will be sent a list of authorities by LSLC very kindly, so you don't need to try and capture them all while I'm speaking. Here we go. I'm going to mention just three things about the knock-for-knock schemes in the supply time and the wind time. I'm not going to try a complex analysis. I'm going to identify what I think are three key characteristics. And I hope that 2 points will emerge from this. One is that the scheme, if I can use that term collectively, the scheme in each of the forms is intended to provide a simple allocation of liabilities among the participants in the work with a view to minimizing the scope for dispute. And the second point, and this picks up on something Simon said in his introduction, is that there are a lot of shipping cases which are very useful in helping to interpret knock-for-knock agreements, not only in charter parties, but also in other contracts in the offshore energy sector, from drilling contracts through other service contracts to offshore construction and so on. I was reading a very erudite article by a Norwegian lawyer yesterday who said that the offshore energy sector is where shipping meets construction. So against that background, I'll quickly set the scene. Now, the supply time form of charter party was developed by BIMCO in the mid-1970s for use in E&P, exploration and production in the offshore energy sector. And the latest version was published in 2017. It was designed for the chartering of OSVs, variously offshore support vessels, offshore supply vessels, or offshore service vessels. The starting point for Wind Time 13 was the 2005 version of supply time, but some features of Wind Time were carried over into supply time 2017, so you get some similarities there. Now, OSVs in the oil and gas sector. These vessels perform a range of functions, including anchor handling, construction, maintenance and repair, and also carrying personnel, equipment, supplies and materials to and from rigs, platforms, and other offshore installations, offshore locations. And they include, among other things, seismic survey ships, anchor handling tugs, and diving or ROV support vessels. And they may also be used as standby safety vessels. Now, Wind Time is described by BIMCO as a charter for support vessels for transfer of personnel and equipment to and from offshore wind farms. But these vessels too may be used for things like ROV support, safety and guard duties. These are two small aluminium catamarans moored in Hartlepool, but there are larger vessels in the industry. And a number of subsea vessels from the offshore energy, the oil and gas sector, have made the transition to renewables. Though I'm speaking as a layman here, so someone will correct me if I'm getting this wrong. I think this hasn't happened much with diving support vessels because there hasn't been much diving required so far in offshore wind farms, but that may change as more floating wind projects come online, where more diving will be required. Now, both the supply time and the wind time are time charters, each with a place of delivery, a defined period of hire, and a place of redelivery. And both forms contain a knock for knock. Going back to real basics, that sort of scheme is intended to create a simple, cost-effective way of allocating liabilities for loss or damage to property, injury and death to personnel, and it's intended to reflect the existing insurance arrangements of the parties, and it's also, to some extent, intended to reflect a degree of risk and reward in relation to the contract. And that apportionment of liability is effected by a series of exclusions and indemnities. And subject to express carve-outs, several of which appear in each of these forms, the broad scheme is that each party takes responsibility for its own people and property. So here are my 3 points about the scheme in each form. First, it applies to two groups. It refers to loss, damage, injury, and death of each of an owner's group and a charterer's group. Now, the definitions are rather different in the two forms, and please have a look at that later because we don't have time to go through all the detail of that now. But the important point is that the aim is the same in both, which is to pick up, so far as possible, all the participants in the work with a view to avoiding disputes. In both forms, the group includes employees of all its members, and the definition of employees extends also to directors, officers, servants, agents, and invitees. Second point, it extends to negligence. Now, it doesn't use the word negligence, but it refers to act, neglect, or default. And in Monarch Airlines, Mr. Justice Clark held that very similar words covered negligent acts. So if you're applying the principles in Canada's steamship, I would venture to say that those words passed Lord Morton's first test. In the orbit valve case, which arose out of the Piper Alpha disaster in the North Sea, Lord Justice Steyn referred to words that were synonymous with negligence, or words which in the case law have acquired a status equivalent to a reference to negligence. But we've seen from recent authorities that we shouldn't be applying Canada Steamship in a mechanistic way. The judgment is an aid to construction. Wind time, unlike supply time, refers specifically to gross neglect or default. Now, the term gross negligence is very often used in contracts in the offshore industry, and the English courts have found ways of giving meaning to it. The interpretation will always depend on the wording and the context of the contract, but generally it's a question of degree. It means very serious negligence. In the Hellespont Ardent, Mr. Justice Mance referred to gross negligence in English law, although he was considering the term in the context of a contract governed by New York law. And he said, gross negligence is clearly intended to represent something more fundamental than failure to exercise proper skill and/or care constituting negligence. He also said, as a matter of ordinary language and general impression, the concept of gross negligence seems to me capable of embracing not only conduct undertaken with actual appreciation of the risks involved, but also serious disregard of or indifference to an obvious risk. Now, that passage strictly was obiter, but it's been cited with approval by Mr. Justice Andrew Smith in the Camerata property case. Now, when I was in private practice, and I'm sure Chris will remember this too, and we were advising on contracts, we used to recommend avoiding references to gross negligence unless it was really necessary, mainly because of the difficulty in drawing a line between gross and ordinary negligence. But the important point here is that in this scheme, under English law, the reference to gross negligence encompasses lesser degrees of fault. Just one word of caution. If you're drafting amendments to either of these forms, and certainly to the wind time form, and you add any additional clauses, it's important to make sure that you use consistent language. Otherwise, you could run into difficulties over whether you're referring to all forms of negligence or just negligence, which is something less than gross. But where a difficulty might arise is in defining where negligence ends and willful misconduct begins. That is something more serious than even gross negligence. And generally, there has to be an intention to do something with knowledge that it's wrong, or at least a reckless act in the sense of knowing that loss may result, but not caring whether that loss will result or not. The term is often expressly defined in offshore contracts to reduce the scope for dispute. And in wind time, there's an express provision which has the effect that the indemnity and hold harmless in the knock for knock will not apply in the case of act or omission committed with the intent to cause same or recklessly and with knowledge that such loss, damage, injury or death would probably result. Now, that's helpful, but nevertheless, the line between gross negligence and willful misconduct is an area where there is fertile scope for dispute. If you'd like to know more, then I commend to you two books. One is the section on gross negligence and willful misconduct by Elizabeth Blackburn, QC, and Jeremy Lightfoot in Offshore Contracts and Liabilities. That's a book to which our learned chair contributed. And I'd refer you also to another of Simon's books, The Law of Tug and Tow and Offshore Contracts, published by Informer. The scheme also applies in the case of unseaworthiness of any vessel. So my third point is that it purports to cover non-performance. Both forms refer to loss, damage, personal injury and death arising out of or in any way connected with the performance or non-performance of the charter party. So why has that reference to non-performance been added? Well, it's because of these two cases. Cap Palos was a 5-masted Canadian schooner, and during a tow in ballast, the tugs got into difficulty in Robin Hood's Bay in North Yorkshire. The schooner was driven onto the rocks and became a constructive total loss. Now, the tug owner, Mr. Older, was protected by the exceptions in his contract for the negligent navigation of the tugs, but he failed to send another tug to assist. It was a bit of a misunderstanding. someone thought the Salvage Association was sending a tug, and he cancelled the instruction to his substitute tug. But in all events, he failed to send a tug to assist, which might have resulted in the schooner not becoming a CTL. Now, the Court of Appeal said that the exceptions were confined to a time when the tug owner was doing something or omitting to do something in the performance of the contract, not when he'd stopped doing anything at all and had left the performance to someone else. 85 years later, in 2006, the semi-submersible rig A Turtle was being towed by a tug called Mighty Deliverer, very inappropriately named. It wasn't mighty and it didn't deliver. During the voyage, the tug ran short of fuel and released the tow while it waited for assistance. And as you can see from this picture, the rig drifted off and landed up near a beach in Tristan da Cunha. The tug owner was relieved of liability by the allocation of risk in the TowCon contract in that case. But the judge, Mr. Justice Tier, referred back to Cat Palos and highlighted the distinction between, on the one hand, ceasing to do anything in performance of obligations, and on the other, continuing to perform the contract in a manner which was not to the required standard. If, he said, for example, a tug owner chose not to perform the contract by releasing the towage connection in order to perform a more profitable contract elsewhere, then very clear words would be required to exclude liability, because that would be a very radical breach indeed, echoing not only the Cat Palos, but also the Swiss Atlantique case in the context of fundamental breach. Now, it remains to be seen whether the reference to non-performance is sufficient in these forms to extend the scheme to deliberate, repudiatory, or renunciatory breaches. There is, just for completeness, one other potential limit on the scope of the knock-for-knock scheme, although it doesn't arise in the context of the forms. In 2016, the Court of Appeal reflected on the question whether an exclusion clause interpreted literally would turn a contract into a mere declaration of intent. It arose from the drilling of an appraisal well by the semi-GSF Arctic 3 and related to a mutual hold harmless and indemnity for consequential loss. The company argued, among other things, that if the clause had the wide meaning for which the contractor was contending, this would effectively remove from the contract any meaningful obligations on the contractor's part, so that it would become a mere declaration of intent. The court acknowledged that this argument was based on a principle that had been applied in a number of cases, but they described the principle as one of last resort. And it's also clearly very narrow in scope. They concluded that it applied only in cases where the clause would relieve one party from all liability for breach of any of the obligations which he has purported to undertake. Only in such a case could it be said that the contract amounted to nothing more than a mere declaration of intent. So in summary, in my experience, the scheme in each of these forms is a fairly recognizable conventional knock for knock. It achieves the aim of providing a simple scheme for allocation of liabilities and minimizing scope for disputes. And a number of shipping cases are useful in interpreting knock for knock agreements, not only in charter parties, but also in contracts for offshore construction, drilling, and other offshore services. Thank you.
Thank you very much indeed, David. And if I can just take over David's slides and go back to the picture of the A Turtle, David mentioned that the tug that was charged with towing the A Turtle was called the Mighty Deliverer. When I've given talks about this case, I've also put a picture up of the Mighty Deliverer, which apparently is on a website called the ugliestshipsoftheworld.com. Have a look and have a look how awfully ugly the Mighty Deliverer is.
Thank you, Simon. I should have drawn attention to the fact that that photograph is after the casualty and that tug is not the Mighty Deliverer.
No, that's not nice
like
the Mighty Deliverer. Right. Well, thank you very much indeed. So from law and contract to procedure and dispute resolution, our last speaker is Claire Ambrose, another very well-known arbitrator, always in demand, who brings her a considerable experience from her former career as a busy commercial barrister to sitting as an arbitrator. She is co-author of the leading text, London Maritime Arbitration, and she's going to give us tonight insights into the practical and procedural features of maritime arbitration translated into the context of offshore energy disputes. What are the differences? What are the similarities? And what expectations are the parties bringing to that sort of arbitration, or should they be bringing? I'm afraid I'm not able to tell you what school she went to because I haven't been able to find out from her website CV. You will perceive the relevance of that remark in a few minutes. If I can just get her to talk now. Third time lucky. Look at that. There it goes. There's the mouse. Thank you very much, Claire. Over to you.
Thank you, Simon. I'm going to focus on the dispute side, and in particular on arbitration, because that's the most common form of dispute resolution in this area. And I'll be looking at two aspects, case management and picking the tribunal. And just to start to understand what you want from the tribunal, it's perhaps useful to start at a very basic level to understand the sort of disputes in play. And most disputes will be contractual. They arise under a contract with an arbitration clause. Typically technical disputes where there'll be expert evidence and often large sums at stake, large quantities of evidence and teams of lawyers. I also flag up that it isn't just arbitration in this area. You do get court litigation, as we've been hearing, and also non-contractual disputes, things like enforcement. Picture here is of the Bonga offshore facility where there was a spill and there's been proceedings. Around 30,000 individuals in Nigeria are suing Shell, and that case is going up to the Supreme Court. They're suing in nuisance. So I also highlight that parties do use ADR, whether it's mediation or expert determination, and those are really important for avoiding costs and preserving commercial relationships. But I'm going to be focusing on arbitration, which is typically the last resort. So turning to choosing your seat, your arbitrator, and the rules, the seat and the rules will typically be chosen in the contract before any dispute has arisen. And I'm not going to focus on choice of seat tonight. We're talking about London, and I'm going to focus on the main choices for parties choosing their arbitrators and choosing the type of arbitration they get. And in here, there's mainly two main choices for parties in that respect, in terms of the type of arbitration and the type of arbitrators. On the one hand, you have ad hoc arbitration, very often under LMAA rules and with the LMAA members. And that's the most common. In the maritime context, typically the LMAA rules will be in play at some stage. Sometimes the parties won't choose the rules, and it will be what you might call a pure ad hoc, where there are no rules dictating the procedure, but typically LMAA rules will come into play. And ad hoc means it's just the parties and the tribunal, and they get to an award, and there's nobody else involved, as it were. And this is most typically used in contracts that are similar to those involving a conventional ship. And so typically contracts like charter parties and for instance, the BIMCO forms that David was talking about, they all contain an LMAA arbitration clause. And a lot of shipbuilding contracts also contain LMAA arbitration clauses. So the other choice is for institutional arbitration. And this is more common on the construction, energy, and project side. And here, an institution administers the arbitration. And the most common ones are the LCIA, the London Court of International Arbitration, and the ICC, the International Chamber of Commerce. And they will appoint the tribunal, manage the finances of the tribunal, and also the issue of the award. Those are things they will always do, and they sometimes do other things. And practitioners in this area of institutional arbitration would call their sector international arbitration. And construction lawyers might typically fall within this group if arbitration is involved. And as Simon and David said, offshore disputes are perhaps at the intersection where shipping and international arbitration practitioners meet. And tonight, probably the biggest constituent are shipping lawyers. However, shipping lawyers these days will also work in energy and the environment, that we don't silo ourselves in the way that maybe previously might have done. But most practitioners do have their home ground, their comfort zone, where they and their clients feel most comfortable. And tonight, I thought it was worth looking at where those boundaries can make a difference and where some of the differences are really more superficial than real. So, so sometimes London arbitration can feel a little bit tribal. You have shipping practitioners and international arbitration practitioners working in their own bubble. And you might ask what link there could be between dairy girls playing hurling and offshore disputes. But the tribes I'm talking about are not warring countries. They're not football teams who are rivals. I would say they're more like neighboring schools. They rarely acknowledge each other. They don't even treat themselves as rivals because they wouldn't play matches together because they play by different rules. But they will often be rather scathing of each other. Anyway, I won't say whether the LMAA is St. Trinian's or the convent school next door. I did go to a convent school, Simon. But I did dare to put the construction lawyers down for Grange Hill, but I couldn't find a picture with them with a football. But I will move on from the 70s to expectations on appointment. So the starting point is that parties will have a say in choosing their panel or sole arbitrator. And the trend across the board, perhaps sadly, is towards lawyers getting appointed. Parties do sometimes appoint non-lawyers, and that commercial people or engineers, people, technical people, accountants, and that can be very useful. But in practice, there aren't that many of them who have the experience to take on a high value and complex dispute. I also mentioned getting a balance. If one side appoints a retired judge or one side appoints a partisan arbitrator, there can be a knee-jerk reaction to sort of do the same, to get an equal and opposite, to have equality of arms. I would say perhaps think more carefully. Partisan arbitrators will not neutralize each other out. They can be unpredictable or are likely to be unpredictable. And with two strong-minded silks or retired judges, you will have a charming tribunal, a heavyweight tribunal, but they may start sparring with each other. And that can be interesting, but a little bit distracting, maybe sometimes. You want a tribunal that works together, that can challenge each other, but also can reach common views. And having a bit of diversity is healthy, whether it's someone more junior, someone with commercial or technical experience, that may add some balance and useful expertise. In terms of the chair, you can ask the tribunal the parties may want to say, and you can ask the tribunal that you want an opportunity to have some say at some consultation. That is unusual in the shipping context, but it is common in the LCIA and ICC context. And whatever rules you're working with, I think you can ask, and I would say most of us would be amenable to it. And that is something that is available. Turning to what makes a difference, a rather small font, I'm afraid. How long does the appointment take, and what does it involve? In the LMAA rules. The appointment process is direct, quick and cheap. You go directly to an arbitrator, you pay £350 appointment fee. In the LCIA and ICC, the institution runs the appointment process, and it can be quite slow. At the outset, the deposit is a lot higher. It's $5,000, £2,000. And arbitrators are required to give quite full disclosure about availability, about previous appointments. And the ICC process can be particularly slow, because literally months if it doesn't go well, because they gather in, typically they will gather in an advance on fees, and that may take time. On disclosure, I've referred to Halliburton and Chubb. That's the leading decision. It's been much discussed. I'm not going to revisit that, but it does make clear that in LMAA arbitration, the practice is for there to be much less disclosure than under other rules. In terms of the differences, some parties will get very frustrated with the length of time the ICC may take. Other parties may be alarmed if they find that the arbitrator that's been appointed by the other side's lawyers has been appointed by them many times in the last year or so. Here, what's important is to manage the client's expectations. You can't change the ICC. You're probably not going to be able to change the LMAA, but you can manage your client's expectations. In terms of concurrent disputes and appointments, here, the LMAA rules make it easy for related disputes to be heard concurrently, and that's normal practice. That's much less common with the ICC and LCIA rules. Both institutions have tweaked their rules to make it easier, but joinder is still quite difficult. And coming from a shipping background, I find that can be frustrating. I was in a panel on a conversion of an FPSO, and there was a subcontract arbitration and then a head contract arbitration. And in the one of these arbitrations, we were trying to guess what was happening in the arbitration above. And I would be interested to hear views as to what the right balance is there. Turning to trends on case management, here different tools suit different parties. Most different practices aren't that significant, and they're probably attributable to the working practices of the firms or the tribunals involved. And there's something that tribunals and parties can adjust to. Most of us from a shipping background are more familiar with pleadings, but memorials are not that different. It's really just that the statements come a little bit earlier. Red fern schedules, they're something of a Marmite feature. Some people have very strong views for and against. I actually find them easier to digest, and I see them more and more across the board. So I think they are coming in. In terms of hybrid and remote hearings across the board in London, there's strength in using those tools. In terms of closing submissions, whether they're made orally or in writing, here there's a bit of a difference in practice, and it's important for a tribunal to be sensitive to what the practitioners are expecting. And if solicitors are doing the advocacy, in my experience, they will normally want to have some time between the end of evidence and making submissions. And if you've got counsel, they're probably more ready and willing and used to going straight on. For the tribunal and perhaps for the client, it suits to move quite quickly because you've got the evidence, you want to write an award, and actually spending weeks exchanging lengthy written submissions is costly. But you've got to balance all these considerations in terms of making sure it's fair, and maybe a compromise is a short timetable so as to keep any delay as short as possible and keep the time being spent as short as possible. Now, managing complexity, we all probably have seen eye-watering sums being spent, not only on the lawyers, but also on expert evidence. And it seems to me there could be greater control over this. Again, a moot point. But in practice, we don't see cost capping. We don't see budgets as we do in the court, in in litigation in court. Expert evidence is heavily budgeted, but we don't see lawyers asking for that in arbitration much, in my experience. And it would be a brave arbitrator who imposes it, but it might save the parties some money. Expert evidence, it also goes to picking your tribunal. If you're going to spend six-figure sums on expert evidence, it may be worth picking a panel member who can really understand that evidence. That is an asset. And in terms of ensuring that the tribunal gets the most out of the expert evidence, it could be useful to give tribunals an advance introduction to some of the technical issues, rather than them only getting into the expert evidence days after the hearing's begun. And I know this is an idea Liz Gloucester has talked about in terms of getting the experts on board in advance of preparation. And so on fees, the institutions collect fees in advance by way of deposit. In LMAA arbitration, traditionally, the tribunal has given its charges when it publishes the award at the very end. And I have heard some clients favor the LCIA system, as they pay the money up front, they pay for the meal at the beginning of the meal, and they don't have to scramble around to pay the bill just at the moment when they want to get the award, when they want to leave, rush off to get the train, as it were. But in fact, in the larger cases, I see a trend towards LMAA arbitrate tribunals seeking a deposit or security. So practice is aligning there, and it does probably give certainty to the tribunal and the parties. Now, in terms of sources of delay and costs, very briefly, speaking from my own experience, it seems to me there can be substantial delay, whichever school you go to. But the ICC processes do build in some periods of delay that can be quite substantial, both at the beginning and the end when they're scrutinizing the award. Probably what makes most difference to delay, other than that, is whether the parties cooperate and whether the tribunal is proactive in preventing drift or preventing somewhat more deliberate delay. And in terms of costs, big offshore cases are expensive, whichever rules you use. Mediation can save a lot of money. The costs of the tribunal and any institution are typically only a relatively small fraction of what the lawyers and experts, those costs. But it's worth highlighting some differences. With LMA arbitration, you only pay for the tribunal's fees, and they charge by the hour. For institutional arbitration, you pay for the tribunal's fees and also the work of the institution. And that could be anything from perhaps 10% of what the arbitrators are getting to 50%. It can vary. For ICC arbitration, you're paying ad valorem, a percentage of the money amount at stake. And fees can be high, and the institution's charges can be higher, for instance, than the LCIA, and that can make quite a substantial added cost. So on that note, I will hand back to Simon.
Thank you very much indeed, Claire. May I have the mouse? I'm told that my technical skills are so good, I'm now going to be asked to do the question and answer session. No questions. Yes, of course. Well, there are no questions on the question and answer. So, ladies and gentlemen, it's down to you. Yes, Robert.
Well, you're already introducing a concept that the parties didn't themselves introduce into the contract. The contract doesn't involve any mention of the prevention principle being applicable to the contract should one party prevent the other. It's silent on that. So we're already in the area where something is being introduced into the contract that the parties by definition didn't do themselves. My modest proposal is merely to introduce something that makes a lot more practical sense and maintains fundamentally the bargain that the parties struck rather than doing away with it. And I think there are a couple of reasons why we can sensibly look at it differently than 120 years ago. One, for example, is that there is a very different view about what liquidated damages provisions are about nowadays. 150 years ago, they were seen as penal to the contractor. And now they are very often seen by a contractor as, quite rightly, a cap on their liability. So it's a bilateral clause as opposed to what used to be seen as essentially a unilateral anti-contractor clause. And I think you only have to sort of introduce that to see that it would be both parties' intention that is maintained. And one can think of lots of examples, and this is the second reason, is that once you get rid of LDs and you see them through the lens of a benefit to the contractor rather than a burden or something that is penal, you're left with the question is what do you replace it with? Well, you replace it with general damages unless you bring in sort of my modified prevention principle. And then you can get the situation, can't you, where an employer can, via an instruction, which isn't a breach of contract, get rid of the contractor's cap on damages. You can't prevent the employer from doing that by saying you can't benefit from your own breach because the employer hasn't breached, they've just instructed something. And how do you deal with that? Obviously, it seems to be utterly inequitable situation where an employer can end up with significantly enhanced damages by reason of their own instruction. And so there, the more you dig into it, the more you see that if you just adopt a sort of to the extent that answer, it deals with all of these problems. And as I say, it's a sort of modest departure from what is already happening, which is the introduction of something that nobody wrote into the contract in the first place. That's my defense.
But also it reflects the concerns that are expressed about the absolute principle.
Yeah.
So it's not as if it's a well-settled principle that everyone's very happy with. It's a well-settled principle that applies, but people think, that doesn't seem quite right.
Yeah, and people are bending over backwards, as we see in those cases, to not allow the prevention principle in. And I think the reason is because this the really draconian impact of it. And I think if you modified what the prevention principle is, you wouldn't have to strain contracts to prevent it from applying.
Thank you. Any other questions? Lovely. Thank you very much indeed, Colleen.
Pauline Hanley from 20 Essex. Sorry, it's a bit loud. Mainly a question for Claire, but I'm interested in what the entire panel thinks. You mentioned ad hoc arbitrations. And I have to say that the few times I've been involved in an ad hoc arbitration, my heart sinks and I feel this sense of dread because it seems somehow slightly Wild West. And do you have any advice on how best to handle ad hoc arbitrations, how to get the parties on board with a set of procedural rules of some kind? Do you find that it isn't a problem out of interest and people default? Or what's your experience generally?
It slightly depends on the parties you have. If you've got parties you're familiar with who know how to run an arbitration, then you can set quite a basic timetable and probably default to LMAA rules. Suggest, wouldn't it be nice to have a nice timetable and an outline that we can work with? If it's not in a context where they're used to LMAA rules, and then terms of reference are useful in that situation because you can spell out confidentiality, fees, timetables, and it's all in black and white. That can be a useful way of getting things on track. But typically bring in LMAA rules is useful in the shipping context. What do you What's your experience?
Can I just add one thing to that? I agree absolutely with Claire. And Colin, there might be one little clarification we need to make, which is the use of the term ad hoc. I think you're talking about ad hoc in the purest sense, if I understand, where there are no applicable terms or procedures. People loosely refer to LMAA arbitration as being ad hoc because it's not institutional. But one thing I would just add to Claire's very helpful answer is that there's nothing in the LMAA terms that restrict them to shipping cases. There's nothing peculiar about them that in any way refers to maritime disputes specifically. They're actually of general application. I just offer that. I mean, it might seem a bit bizarre thinking about using the LMAA terms in an ad hoc dispute that has nothing whatever to do with a maritime context, but certainly in the context that we're talking about, which is the offshore energy sector, where actually a lot of that is taking place in a maritime context, then it's not a big jump to use the LMAA terms.
Do you find the parties tend to agree, or do you get more kickback? You know, on
Well, very difficult to generalize. I mean, the answer is that the LMAA terms are expressly provided for in a lot of contracts. Yeah. And in my experience in the energy sector, if they're not, there tends to be an institution provided for in the clause. So we don't often, my personal experience is I don't often find myself with pure ad hoc cases. But other people might have other experiences.
Yeah, I mean, I think for a pure ad hoc case, as Claire said, much depends upon the experience of the parties. If they're savvy, then it may be easier for the tribunal to get them to line up to a set of rules. But I think also what is very important then, who are the arbitrators? Because the arbitrators will have, well, many arbitrators will have on their laptop ready to go a set of terms of reference, sometimes grotesquely long, sometimes covering every eventuality in far too great a detail. But they will have a template which they can ask the parties to debate, and that's how I find the problem usually gets solved. You get a chairman who says, "Well, I'm going to shake this up. This is a set of rules which I've crafted from other arbitrations, not necessarily tied to any institution, and this will be the procedural way of doing it." Because as Claire said, there are a lot of important points to cover: confidentiality, all the things that no one really thinks about.
Thank you.
Thank you, Colleen. Chris, I hope we've got a really difficult question for David.
That's a really good question, Chris. And I'll answer it in those two parts. But I'll just preface it by saying that this is part of, sorry, this sounds a little bit like a commercial break, which it isn't intended to be at all. But the LMAA has recently beefed up what you might call its ADR offering. Alongside arbitration, we're offering early neutral evaluation as well as dispute boards now. The idea being that we think it's important to have a suite of dispute resolution available. And of course, this is a slight digression, Chris. I will come back and answer your question in a moment. But to take ENE as an example, it seemed to us that it would be potentially really valuable for parties to be able to have ENE conducted by an arbitrator, not the arbitrator who will ultimately resolve the dispute, of course, if it isn't settled, but somebody who thinks as an arbitrator and is might be representative of how the dispute is likely to be resolved. Anyway, coming back to the question of dispute boards, yeah, the thinking there was that we had seen them used in land-based construction disputes. Adam will be very familiar with the use of dispute boards. It occurred to us that there were really, broadly speaking, two categories of case where it might be useful in the maritime context. One is long-term shipping contracts where there is a continuing relationship between the parties over a period of time. It might be useful to them to have a board that they can consult from time to time to help them resolve disputes as they arise. And the other, obviously, is any sort of construction project that has a maritime component to it. Could be shipbuilding, in some ways, it's less likely to be conventional shipbuilding because the projects are more straightforward. But if you're getting into the sort of stuff you and I used to do, the complex offshore construction cases, then there is a role for that. The answers to your questions in order are no. To be blunt, it hasn't really caught on with the LMAA yet, but the qualification to that is that it's only really quite recently been introduced, and it's part of our job to make people more aware of it. There are a number of members who, on the website, offer to act as dispute board members, and it struck us that one of the things that might be useful, take for example offshore wind farm projects, which is one of the things we're talking about this evening. You might want to, because there are land-based and maritime components to projects of that sort, you might want to mix and match in your dispute board. You might want an engineer who's familiar with the kind of construction work or fabrication work that goes on in the yard, ashore. But at the same time, you might want someone who could pick up any disputes that relate to the offshore part of the work, the installation work or the vessel charters or whatever. So that the answer is no, it hasn't caught on yet, but we are publicising it. The answer is we hope it is here to stay because, as I say, we see this very much as part of a suite of dispute resolution. And I take your point. There's always this worry, isn't there? That if you overcomplicate the dispute resolution clause, you're going to go through all these levels of mechanism. But I don't see that as such a problem with dispute boards because, of course, by their nature, they're there to help while the project is progressing. So it's not quite the same as saying, well, before you go to arbitration, you've got to have discussions between the chief executives, and then you've got to have mediation, and then 80 days after that, you've got to have something else, and then you can arbitrate. The idea here is that this would be a process that would be available to the parties during the currency of the project. What's your view? Do you think it'll work? That's helpful, thank you. And then you've prompted just one further thought, which relates to the parties in the offshore energy sector. I mean, we used to have this experience when we were dealing with oil companies and contractors that these people depend on each other for their livelihoods, and the last thing they want to do is get themselves locked into long-term arbitration. So they were always interested when disputes arose in having quick and dirty, cost-effective ways of resolving disputes. And I think the same applies. Now, I hear the same thing said about the wind farm sector. There are contractors, vessel operators, there are a certain number of wind farm operators, and they're part of a community and they depend on each other. They don't want to end up locked into long-term disputes. Thanks, Chris. That's really interesting.
Thank you very much. Are there any other questions either from the floor or the Q&A function is now working? Online, otherwise, as it's coming up to 10 to 7, I will draw this part of the evening to a close. And I don't think any corks have popped yet, but I'm sure they will very shortly. If that's all, then can I ask you in a nice old-fashioned way to give a round of applause to our excellent speakers. Thank you very, very much indeed.